bit unfair to me that George Romero's out of luck under our constitutional scheme for copyright, but a Russian composer who Mr. Golan was trying to, use his works.
Well, I get that, but here's the argument. American citizens are presumed, at least in the eyes of the law, they're presumed to know the law. That doesn't mean they always do, but they're presumed to know it. Someone who's on the other side of the earth, and who really at the time of publication didn't even intend to exploit the US market, shouldn't necessarily be chargeable with knowing that if they published their work without putting a copyright notice on it, it was going to go into the US public domain. And that's part of the rationale for quote, restoring the copyrights in those foreign works that didn't comply with our formalities. The notion is they didn't even know they had to. And why should they have known they had to? So take it or leave it, that's the notion.
And just to follow up on that a little bit, I mean, that's reflected in the way that the statute gives protection. So for example, it's not if I wish my memory was just a little better, but I believe for works that were simultaneously published or attempted to be simultaneously published, and for example, formalities were not followed, those works were not restored even if there was an author. So if Congress, when it drafted the statute, took special care to apply it only to those authors that essentially didn't have constructive notice of what what the United States statute actually said. Now, nobody has to like it, but that's what they tried to do.
You have a question? Yeah.
Hi, my name is Tamara Weingast. I'm a student at WCL. I just wanted to build off a couple of the ideas from the public domain discussion that you were having. It almost seems like because the copyright and the patents power are in the same clause, there seems to be a distinction between, in copyright, when you're talking about public domain, between those things that are never copyrightable and those things which might have had copyright and are no longer copyrighted. And it seems that you can almost parallel that to the idea of patents in the same clause. If there are those things which are never patentable, and then those things of which there were a patent, and now the patent has run out. So I was wondering if you could speak to that parallel, and whether, if you see that sort of classification maybe perhaps being helpful going forward.
Well, not copyrightable is different than not copyrighted, right? So there may be some things that you can simply never get a copyright on. The things we're talking about here are obviously things that were eligible for copyright protection but didn't get any for any reason. Right,
but in terms of thinking about them as being two separate things in the public domain, might there be a better way for us to conceive of them, those things which are in the public domain and were never copyrightable versus those things which are now in the public domain and were copyrighted at one point?
Yes, I think that distinction is very important, because when you're talking about the second category, you're talking about things that were brought within the federal scheme, that were covered by federal copyright law. And in each case, you're talking about a